This is the first iTuesday for the month of October, and we are in the last quarter of the year, but somehow we still have very interesting and pertinent topics to discuss amongst our product lines. And we've got a great team joining us this morning with the claims team. Morning, Vili. Good morning, Nadia and Carmini as well, the #1 claims team in the country. That's just a personal opinion, but I think that's also an industry fact, eh? So Vili, if you wouldn't mind just introducing us to what we're going to be discussing today, as well as who's joining us.
Yeah, good morning. Thank you very much, Mometi. We today have Lee Astfalk with us. Lee is a partner at Clyde & Co. He has extensive experience for over 20 years in terms of dispute resolution, and he has given specifically insurance advice to many commercial clients and insurers over these years. He also has, in particular, a good experience, very good experience in directors and officers liability lines, other financial lines, professional indemnity, fidelity guarantee, cyber claims, and data protection. The list goes on and on. I can personally vouch for Lee. He's given the Hollard Group advice and assistance over the past good part of 11 years, and Lee is probably one of the most professional guys you will get in the market. So thank you for being with us, Lee, and thank you for sharing your knowledge. Then last but not least, Nadia Shiba. Nadia has an LLB degree and also has a higher certificate in insurance with more than 15 years general insurance experience. Nadia Shiba is our specialist claims manager for medical malpractice, financial lines, and also cyber. I had the pleasure to have Nadia in my team for the last 6 years. Nadia, thank you for everything you do and always for your upbeat personality. And for those who don't know me, I'm Willful Jansen van Rensburg. Now, for my sins, I'm looking after the claim team for I2. Then without any further ado, I would just want to ask the audience that any questions, please post it in the chat box. We will, after the presentation, address all those questions. And even if there's no time, we will address it afterwards by way of correspondence if need be. And from that, I will hand over to Lee to attempt to deconstruct the D&O policy. Thank you, Lee.
Thanks, Vili. Thanks for the very kind words. When you describe me as an attorney with 20 years experience, I feel rather old today, but I'm very proud to have been associated with you and your organization for so long and watch the tremendous growth of I2 in the market. And particularly in respect of directors and officers liability insurance, which is a fairly unique creature amongst insurance policies. So what we're going to do today is just give a high-level overview of the D&O policy, how it's structured, and what it's designed to cover. And we will just draw some distinctions between the D&O policy and other policies. That will set the scene, and from there we will go into some more detailed questions involving both Vili and Nadia and myself in terms of more specific details regarding the D&O framework landscape at the moment, the types of claims we have seen, what we think we will see going forward, because of course we live in such interesting times. So just in terms of introduction, and as I say, in terms of a high-level overview, the D&O policy it's a unique policy, and as many of you brokers on the call will know, it has a fairly unique structure. You need to, at the outset, draw a distinction under the policy between the company, who is the policy holder, and the individual directors who are the insured persons under the policy. And that gives rise to sort of an interesting situation, because generally it is the company as the policyholder that engages with the insurer. The company will negotiate the terms with the insurer, will complete the proposal forms, will agree the terms, and will ultimately pay the premium under the policy. But the policy itself is specifically designed not to protect the company, but the individual directors acting in that capacity. And therein lies a distinction that needs to be made at the outset. And what makes that even more interesting, and we'll get into some of the detail today, is how the company as the policyholder is also often one of the parties that might bring claims against the directors. So there's an interesting distinction to be made there. But the bottom line is it's designed to protect the directors in their personal capacities. The other thing to note about the D&O policy, just by way of introduction, is you must always make a distinction between a traditional professional negligence policy and the D&O policy itself. A PI policy, again, as many of you will know, is designed to indemnify a professional. And by definition, a professional is someone with a unique set of skills, often having required specific qualifications in order to qualify as a professional. And there's obvious examples, insurance brokers being one, attorneys, doctors, architects, and the like. And the PI policy is designed to indemnify the professional acting in that capacity and providing professional advice to their clients. That must be distinguished from a D&O policy, which is designed to indemnify the individual directors acting in that capacity and discharging their duties to the company. So you can see that the key to differentiating between PI and D&O, in my mind, the easiest way to think about it is the capacity within which the individual person is working. And when D&O policies were first drafted and developed, particularly in the London market, there's always been this historical debate about whether a director is a professional, similar to an insurance broker or a doctor. Certainly, directors are required to act in a professional manner and in the discharge of their duties to the company. But if you think about it, there's no specific skills or qualifications that a director needs. Literally any person, bar certain excluded categories, can serve as a director of a company. So again, therein lies that distinction between a professional who has certain skills and qualifications and a director who acts in a different capacity. I've also mentioned, just in high-level terms, the duties of directors, and let's just sort of summarize those. There are two key duties that a director owes to a company under our law. The first is a fiduciary duty. That is to act in the best interests of the company. You have to put the interests of the company before your own personal interests. And that's a very high duty in law. It is, as I understand, the highest duty that you can get in terms of a duty of care. So you have to put the interests of the company first. The second duty that runs parallel with that is the duty to act with the appropriate degree of care and skill. That is a duty to act as a reasonable director, objectively speaking. So those are the two duties that directors have, and very importantly, they owe those duties to the company itself. So those are the duties, and that is generally how a D&O policy can be distinguished from PI. And secondly, that distinction that you have to make between the company on the one hand and the directors as the insured persons under the policy. A D&O policy will then have, like any other policy, it will have various insuring clauses. And typically, in a D&O policy, there are 4 insuring clauses or operative clauses. Your first clause will indemnify the insured person for wrongful acts. And the definition of a wrongful act under the policy is extremely broad. It can include any actual or alleged act, error, or omission. So the cover provided by a wrongful act is very broad. It can cover all manner of claims and potential risks. And I think that's important to bear in mind when you sell these policies, that you draw the insured's attention to just how broad that definition of a wrongful act is, because that is the trigger to cover under the insuring clause of the policy. You often then have a second insuring clause, which essentially says where the company has indemnified a director who has been met with a claim or a liability, then the company can call upon the insurer and be reimbursed. And that traditionally was called side B cover under the Lloyd's market. So there it might be the case that a director in the lawful and proper discharge of his or her duties has been met with a claim by a third party. The company has assessed that claim and has agreed to indemnify the director for any consequences arising out of that liability. And in that situation, the company itself can then look to the insurer for reimbursement. But bear in mind, that's only reimbursement of what they've paid on behalf of the directors. So that underlying principle remains that it is the director, him or herself, who is the insured person under the policy. You then have what's called traditionally side C cover, which is a type of cover that extends to the company itself. So here is the one exception where the company itself might benefit from cover under the policy. And it relates mainly to securities type claims. Those are claims that arise out of disputes relating to the securities of a company. It might be allegations that the directors have made a decision and the share price or the value of securities of the company has plummeted for whatever reason. In my experience, and I'll be very interested to hear from you as an audience today, South Africa, we haven't seen much in the way of securities type claims, but you only have to look to the US. Literally every month, there is a class action lawsuit being launched that flows out of securities type claims. So it's something that we might see more of in time. So that's insuring clause 3 or side C cover. We then come lastly to what for me is one of the most significant benefits of a D&O policy. And that is the operative clause that provides for advanced defense cost cover. So there, the insurer is saying, if you, Mr. or Mrs. Director, are met with a claim, we agree to advance defense costs for you to defend that claim until ultimately there's a decision made by the court. And this is something that you should always be highlighting when you discuss these policies with potential insureds and you are selling them to insureds. Because typically, litigation involving directors tends to be complex. We find that the litigation has a very long tail. It can last for a long time, and often there are complex factual and legal issues at play. So for directors to have the benefit of a D&O policy sitting behind them, where they can access the cover and the benefit of advanced defense cost cover in today's world, that is crucial. That type of cover, and we'll probably delve into this detail a little bit further, but it goes beyond claims involving mere negligence. It can operate to provide legal costs to directors, even where there are claims stemming from intentional misconduct, alleged intentional misconduct, and criminal summonses. And I'll go into a little bit more detail when we talk about specific claims in due course. So those are the insuring clauses. That is what the policy is designed to cover. As I say, it's fairly broad in nature, and there is the significant benefit to insureds of the defense cost cover. There are also various extensions to cover, and again, I won't go into that in too much detail because we want to speak about that a bit further later on this morning. So that's sort of a high-level overview of the D&O policy, the duties of directors, and what the policy is designed to cover. So I'm going to pause there and revert back to Willie before we move on.
Thank you, Lee. Thank you for the insight. Nadia, I'm sure you have a number of questions for Lee. Please, yeah, go ahead.
Good morning, Lee. It's always great to have you with us. So in your years of experience, right, have you seen an increase in the number of claims against directors, and what has actually contributed to this?
Thanks, Nadia. So yeah, I mean, it's interesting. Probably going back 10 years or so ago, people in the market were saying, where are the D&O claims going to come from? We had not seen much in the way of litigation against directors, and we were quite far behind the rest of the world, US, the UK, and Australia in that regard. Locally, I think what we have then seen is a significant increase in claims against directors, driven by a couple of things here locally. I think the first being the intense focus on state-owned enterprises and the conduct of directors there. And we all know that there's been a huge amount of scrutiny on SOEs, and there's been litigation that has flown from that. So that has been a big driver, I think, in raising awareness. And then that was followed swiftly by some large-scale corporate failings or alleged misconduct, and we can think of Steinhoff. So we've had some significant things happen locally that has contributed to the increase in claims. I think more broadly, and again, South Africa is seeing this, we've seen a move towards individual accountability. So claimants going beyond the corporate veil, beyond going after the company, to the individual directors themselves. And that move towards individual accountability has been coupled with a growing awareness by claimants that they have the legal means to hold directors to account. There are mechanisms in our law that they can employ to bring legal action against directors. So if we think of our Companies Act, there are provisions within the Act that set out what the duties are of directors, and you can go and test that in any particular situation. There are provisions within the Act that allow claimants to bring legal proceedings against directors. There is, for example, class actions as a mechanism and other things. So there has been a growing awareness that you can call upon individuals and hold them to account for the decisions that they make in the course and scope and management of companies. What we've also seen, quite interestingly, is the emergence of collective action and coordinated action by classes of people. So I've already mentioned class actions as a legal mechanism. Social media campaigns, we've seen how quick people are to use social media to bring focus on companies and directors, increased shareholder activism, groups of shareholders working together, going to AGMs of companies and lobbying for support and change within the companies. Trade unions is another example of how you can get this sort of coordinated collective action. So all those sort of underlying factors, I think, are driving claims against directors. And then lastly, we've also seen heightened regulatory scrutiny and activity. So we are seeing more and more here and globally, regulators taking aim at directors. And what we've also seen internationally, which is quite interesting, is increased cooperation between different regulators in different jurisdictions. And one of the things that has driven that is the ability of regulators and claimants and plaintiff law firms to deal with large data. So the development of AI, the development of software to deal with large data has allowed regulators in particular to share data around the world, to analyze it, to coordinate activity and regulatory action against directors of companies. So again, if you are dealing with insureds here who might be looking to take cover out, not just within South Africa, but to have a broader jurisdictional aspect, the policy that can provide cover for regulatory investigations can be hugely beneficial.
Okay, and Lee, where have you seen the most D&O claims coming from, and who have been the typical claimants in litigation, or as they bring forth action against the directors? Yes,
I'll be interested to hear what your take is. I'll give you sort of some of the things that we've seen. As I mentioned at the outset, the company is the policyholder, but the company itself is a significant driver of claims and is often the primary claimant against directors. And if you think about it, that makes sense, because the directors are appointed by the company. They are tasked with the legal responsibility to manage the company. And as I mentioned at the outset, their duties in law, their fiduciary duties, and their duty to act with the appropriate degree of care and skill is owed to the company itself. So the litigation that we've seen in the last 7 to 10 years, 8 to 10 years, much of it has flown from the company taking action against its own directors and saying, we allege that you breached your duty in some shape or form, and we as the company have suffered a loss, and we are looking to you, Mr. and Mrs. Director, to recover our loss. Within that, just to give an example, what we often see is allegations that the directors breached internal policies and procedures that they were meant to follow. We've seen allegations that they've breached their authority levels within the company. That's an interesting one, because often in private companies, there can be a sense that directors can do what they like, and that's not always the case. There are instances where directors have prescribed levels of authority. It might be, for example, a monetary value in terms of transactions that they can enter into. And we've seen claims where the company has said, that was your authority and you've breached it in some shape or form. We've also seen claims targeted at allegations on directors that they failed to implement appropriate internal controls in order to protect the company from things like fraud. And again, directors that might be tasked with the responsibility of the financial affairs of the company, that is something that they might have to deal with in due course. So that's the one sort of area that has really driven claims against directors. A couple of others, misconduct type claims, alleging that the director's conduct is so bad that it's deserving of an order of delinquency. So we've seen delinquency proceedings where the company is seeking an order to have the director declared delinquent, which means that they can no longer serve on the board of a company for a prescribed period. And one that has been in the press, and which I'm sure the audience will be familiar with, is the Dudu Mjeni SAA delinquency proceedings there. And delinquency is it's a misconduct hearing, so it's normally factually very intense, and you have to delve into the conduct of the director. And it's interesting because it's not like a monetary claim where you might be able to settle it on commercial terms. Here, the claimant is saying, I want to go all the way to get an order against that particular director. And it has very serious consequences for directors. And then lastly, from my side, Nadia, I think the increase in criminal summonses that we've seen against directors has been interesting to note. And the classic example there is our environmental legislation. So in South Africa, under the National Environmental Management Act, NEMA, there are provisions that allow the authorities to take criminal action against directors for breach of environmental legislation. So that's been an interesting sort of trend. That's some of the things we've seen. Nadia, I'm sure in a claims environment, you may have seen some others yourself.
We have actually, and I think you've touched on a lot of things that we've actually seen as well. But I think from our side, we've seen a lot of claims arising out of defamation. That's on the increase, matters arising out of reckless trading. And you've actually touched upon the big issue where directors basically acting out of scope of authority or not having the proper mandate. So that has been another big one, and also misleading information. I think where statements are provided which doesn't actually convey the correct and accurate position of the company. So those are the big ones. And I must say, Lee, it's a very interesting time now, like as you've touched upon how things have changed and people are empowered. It's very interesting to see how, the type of claims that we're receiving. So, we can never ever say that a certain type of claim will never reach us. So it's interesting developments are happening on our side.
Yeah, and I think,
sorry,
Billy, you go ahead.
No, you go. I'll ask.
I would add one more to the list that Nadia and I have put down, and the other one, of course, is sort of insolvency related claims. So allegations of reckless trading against directors. That's very pertinent in today's environment where we have tough economic times, and there has been a focus on the decisions that directors have made and allegations about whether the company is solvent or not.
Yeah, thanks, Lee. Lee, you've mentioned Steinhoff. I mean, the Companies Act is well over 10 years old now. And at the time, the doomers and gloomers, they've predicted massive class actions for the South African market as well. But in reality, we have only seen a handful, of which Steinhoff is an obvious and a good example. Why, in your view, have we not seen more class actions in our market?
It's an excellent question, Billy, and it's a tough one to answer. I'm sure there's different views out there as to why that is. I think from my perspective, I think what is important to note at the outset is that whilst our Companies Act and other legislation in our law provides for the mechanism of a class action, it's not just there for the taking. You have to obtain certification from the court to proceed with a class action. So there are there are procedural and substantive requirements that the class of claimants need to meet at the outset in order to have the class action certified. So they have to establish certain things in terms of their claim, their joint claim. They have to establish that there's commonality amongst the class of claimants. They have to go some way to setting out their damages and the like. So in our law, it's not the case that you can just proceed off the bat with a class action. There is a procedural and substantive requirement. And we saw that in Steinhoff, where there was a class of claimants that brought a certification application that was ultimately refused. I think what we might see going forward is an increase in class actions because there are certain things that will probably drive it. And we've seen that internationally. I think the growth of plaintiff law firms who specialize in the pursuit of class action lawsuits is something to keep an eye on. They often work in conjunction with plaintiff law firms from other jurisdictions. They pool resources together. So that's something that might drive class actions locally. I think the time will come where we will see a class action proceed beyond certification to trial proceedings. And ultimately, we will see, I would think, awards of damages in some shape or form, or trial proceedings that might lead to settlements. But that in itself, again, will grow the awareness of claimants as to how this mechanism can be utilized in our law. So that also links to the third point, which I think is just a growing awareness amongst consumers about it. And then lastly, and probably most significantly, and this is a global trend, we might see the emergence of litigation funders. In fact, they are here, and it will be interesting to see how their sort of presence in the local market might drive these types of claims, where they are prepared to fund class action lawsuits, obviously on a commercial arrangement where they then will make a recovery at the end of the day. So I think those are the types of factors that might drive class action lawsuits in South Africa.
Okay, so Lee, there's been a misconception that a listed company should only have D&O cover. Why is it that a private company should also have this cover?
Yeah, it's an interesting sort of perception and misconception which I think is correcting itself over time, but is still there. I mean, the bottom line, Nadia, is that directors of private companies have the same duties in law as directors of listed companies under the Companies Act. So in a nutshell, they face the same risks. They can face the same type of claims. And what's very interesting with private companies and SMEs, and this is a generalization, but often they operate without necessarily having the same resources as larger listed companies. They might not have sort of internal legal departments, risk compliance, whatever. So it's an interesting sort of misconception, but ultimately at the end of the day, they have the same duties and they face the same risks. And we have seen an increase in claims against both private companies and SMEs. So we've seen, again, as I mentioned earlier, directors being dismissed for breach of mandate, going beyond their permitted authority. So not only being dismissed, but then having claims brought against them for alleged damages. We have seen employment practice liability claims, EPL claims, for example, against CEOs for alleged discrimination within the workplace. And again, we have seen criminal proceedings being brought to bear on directors of private companies for environmental infringements. So those are some of the claims that we've seen against private companies. And I think it is an interesting misconception or perception that only listed companies need D&O. I mean, the D&O policy being quite unique, as I mentioned at the outset, you do find that there are sort of these perceptions about what the policy does and does not cover, and there can be misconceptions. And I think that's where the brokers play such an important role. And I know as an insurer, and Willie, I know this is something that you've experienced, that there are other sort of perceptions about the policy that arise from time to time. And maybe you would like to comment on that.
Thank you, Lee. Maybe just from the top of my head, employment practice violation is certainly one. We've had a case not so long ago where a director was dismissed by his company, and he wanted to claim under his D&O policy, and more specifically under the employment practice violation extension. But obviously what he did not realize, and the broker, was that it's not a legal pursuit policy, it's a legal defense policy. So it does, the extension doesn't enable the director to bring actions against other parties, in this case in particular against the company. However, if any of the other employees, if they bring a case against him in his capacity as a director for any employment practice violation, that is when this extension will kick in and assist to defend him and pay in the event legal liability is attached. The other misperception, still within the employment practices liability, is also that the company enjoys cover if this extension is taken out. And it is, again, not the case. It is only the director that enjoys cover in his personal capacity. So brokers out there must make sure that they have separate employment practices liability policies for the company and all the employees. That's one that I can think of. Another one we've had not so long ago is in terms of emergency legal defense costs, where costs were incurred without consent from the insurer, and reimbursement was requested. Now, the emergency legal defense cost cover makes provision for the insured to incur reasonable and necessary costs if it is a matter of urgency, and the insurer can then retrospectively provide his consent after the fact. But the onus is still on the insurer to prove that it was as a matter of urgency and that the costs that were incurred were reasonable and necessary. And maybe a last one is confusion of whether associated companies, subsidiaries are covered. In terms of our policy, subsidiaries are automatically covered in the policy. And I would invite the brokers to go and read what our definition of subsidiary is. It's not only when you have more than half of the issued share capital or equity. It's also if you controls the composition of the board of directors, or in the alternative, if you control more than half of the shareholder or equity voting power. So it's not only so in terms of our definition of subsidiary, it's not only to do with the holding of shares, but those other 2 points as well. Yeah, so those are just the three that I can think of on the top of my head. Lee, maybe I can, since you're the most cleverest person in the room, I'm going to bounce a few questions back to you. As businesses, obviously with the COVID pandemic, we businesses facing increasing and unique challenges as a result of this pandemic, and they are increasingly under huge scrutiny. And this, without saying, heightens the risk of claims and litigation. What, in your view, are the potential risks for D&Os in a crisis, specifically such as COVID-19?
Thanks, Billy. There's a few examples that we can immediately speak to that we've seen, again, just internationally, which is always interesting to look at. So there have been mis-selling type claims arising out of the COVID pandemic. As an example, a Norwegian shipping line was met with a claim that its sales staff were misleading their customers, mis-selling the sort of bookings on this cruise ship, in the sense that they were allegedly wrongfully saying to potential clients, it's safe to be on a ship, it's safe to be at sea in a COVID pandemic. So that's one type of claim, sort of mis-selling claims. We've also seen misrepresentation type claims. So claims being brought against directors alleging the wrongful promotion of protective personal equipment and the safety sort of benefits and features of PPE. So again, misrepresenting to the public. And we've seen as well claims based upon allegations that the directors have underplayed or understated the financial impact of the COVID pandemic on the company. And that's an interesting one because, as we've already mentioned, we are in a world grappling with a pandemic and with the economic reality and impact. So I think that particular aspect, how directors present financials and the financial well-being of the company, its solvency in the context of a pandemic is an interesting one to watch. And then I think also in terms of South Africa specifically, I would anticipate, to your point, an employment practice liability type risk perhaps arising in the near future, because we live in a world at the moment where there is greater scrutiny on workplace health and safety protocols and policies. Companies, of course, are grappling with how to deal with return to work type policies and how to manage the health and safety of their employees. Of course, we're all aware of the burning issue of vaccinations. I mean, every day in the press, there is articles about mandatory vaccinations, the constitutional rights of individuals. So that's an interesting one that might play out. And it's always possible that we will see some sorts of claims being brought against directors within that sort of context. I think the point, Willie, is when we see sort of a crisis like this, it comes down to foreseeability. These are the types of risks that are now arguably are foreseeable. You know, directors are aware of the environment that we live in, and they have to take the necessary steps to guard the company and its employees from these types of risks. And in our law and in the Companies Act, there's something called the business judgment rule. And that is the defense that a director can rely upon when met with a claim. And it has a number of aspects, but one of the underlying principles of the business judgment rule is that it incorporates a proactive obligation. Directors have to take steps to become informed about matters within the company. You can't just sit back and rubber stamp things. You have to proactively go out there and apply your mind to it. So when we look at a situation like the pandemic, I always say to directors when we're talking about sort of appropriate risk advice, steps that can be taken, to always bear in mind that their duty in law encapsulates a proactive obligation. So they need to assess the risks, they need to identify whether they're relevant to a company, and they then need to put in place the appropriate policies and procedures and mechanisms to protect the company and its employees. And then crucially, they need to monitor that, and they need to ensure that there is compliance with it. We're speculating, Willie, it's going to be very interesting to see in the next few years what might emerge from the COVID pandemic, and you know, I'd be very interested to hear from the audience and the brokers as to what their views on. I think if we come back to this question in 24 months' time, we might have some more concrete examples to discuss.
Okay, so Lee, globally hot topics like carbon emissions, cyber threats, COVID-19 vaccination, and the list goes on. In terms of future trends, which risks locally would you say, in your opinion, are the ones that we should be watching out for?
Thanks, Nadia. So, look, I mean, we've given quite a lot of sort of detail already about, you know, the types of claims we have seen and which I think we will see. But in answer to your question, there's a few that stand out for me. I think the first one is what we call event-driven litigation. So that is litigation that arises after a major event or a major disaster that has a fundamental effect on the company and may also have a fundamental effect on its share price. So we've spoken about the COVID pandemic. That is an event, and we might see litigation arising out of that event in due course that is specifically targeted at directors of companies. There are other examples of event-driven litigation that has given rise to claims against directors. If you look abroad, you can think of the litigation against Boeing arising out of air crash disasters, the Boeing 737 being one, and there was shareholder and other litigation action taken by claimants against the directors. There have been or has been litigation arising out of product-related events. So there's litigation against Johnson & Johnson and its directors in terms of some of its products and the health and safety features. And then litigation arising out of natural disasters. For example, major fires. If you think of that horrific fire at Grenfell Tower in London, and you know, the loss of life that happened there, and as I understand, there is litigation that arose out of that, as an example, against the supplier of the cladding panels to Grenfell Tower. So as I say, I think event-driven litigation is something that we might see here in South Africa. And then a few others, cyber security and data and privacy breaches, we know is a very hot topic at the moment. We will all have seen in the press the significant number of ransomware and malware attacks on government institutions and private companies. And there's always the possibility within that sort of event that regulators or claimants might look at the directors for recovery of damages. And I mean, just to give you an illustration, because I know particularly amongst the broker market, just how sort of topical this is at the moment. But if you look at POPIA, just to give an illustration, under POPIA section 109, the regulator is empowered to impose administrative fines of up to 10 million rand on companies in certain circumstances. But within that, there is a number of factors that the regulator has to take into account when imposing that fine. And one of them is whether there was a failure to carry out a risk assessment or a failure to operate good policies, procedures, and practices to protect personal information. Now, yes, the regulator might impose that fine on the company, but who's tasked with the responsibility for implementing the policies and procedures? It's the directors. So you might see in that sort of context, sort of knock-on litigation against the directors. Again, I'm speculating, but it's the type of area that might give rise to claims. And then two others, we've already mentioned the one, employment-related wrongful acts, the EPL type policy. Again, you can look at the Me Too movement in the US and you can see how much litigation arose there, targeting directors. So I think that will remain as a possible source of claims going forward. And then lastly, and no surprises, climate change. And we might well see in time climate change claims with a focus on a breach of fiduciary duties and duties of care and skill by directors. And sort of a few spring to mind. There have been allegations that directors have failed to comply with legislative reporting requirements. There have been allegations that they've published false or misleading information on climate risks and the company's steps to deal with those risks. And there have been allegations that directors have failed to properly assess the impact of climate change on the company and the subsequent damage to company assets. And again, if you just think of the enormity of the Australian bushfires that we saw last year and the huge amount of damage there and property damage there and damage to companies and their operations, again, that is the type of area that might generate claims against directors. So there's a fair bit for directors to think about. We do live in a world of evolving risks. That's easily sort of seen with, as I say, the big C's, climate, COVID, and cyber. Claimants are always looking for ways to formulate claims against directors because of that personal liability. So I'm sure that there will be other types of claims that will emerge in time. So that's some of the examples, Nadia. I think that probably brings us back quite neatly to where we started just over an hour ago in terms of the D&O policy. And perhaps I'll leave it to you to sort of just elaborate on the implications for those companies and directors if there's no D&O policy in place.
I think it's, the problem with not having any cover, with the director sitting on multiple boards, the exposure to claims is huge. You have Section 77 of the Companies Act that provides that in the event of a breach of a director may be held liable for the loss sustained by the company. So if a director does not have the cover, he can be held liable in his personal capacity, which means that he or she will have to pay for the defense costs or any other associated costs. And this obviously would have a grave financial impact on the personal assets of the director as well as, career. And as you've mentioned earlier, you've mentioned that litigation can be at times quite technical, it can be quite complex. So these matters can, the cost implication for directors is huge.
Thank you, Nadia. I think that is probably from my side, what I wanted to sort of set out for people today. Vili, I'll hand back to you.
Yeah, thank you. Tove, Mwete, are there any questions from the
We
audience?
do have a few. Thank you so much, Lee. Thank you for educating us and imparting that knowledge. We appreciate the multitudes of perspectives and answers that you gave. We do have a number of questions in the chat box, and we're about 5 minutes until the end of the session. So if we do run a bit over, please oblige us if you have the time, but otherwise we will respond with answers to your questions via email if you would just supply us with your email address. Okay, so I'm just going to jump around a bit. Some of the questions you did incidentally respond to in your further communication. But Warwick, our Chief Underwriting Officer, actually had a question. Warwick asks, in the case of the recent riots in KZN following the fire chemical plants, is there cover for directors? And if they did not apply for the correct license or permission, have they got defense costs?
Yeah, I trust Warwick to always ask the hard questions. So I think in terms of the first part, if there is often under D&O policies, and I'm sure under I2 there's often sort of a pollution style extension. It might operate to provide defense costs to directors. It might even go further and indemnify them for any civil liabilities that they found to face in time. And we have dealt with claims where policies in the local market have responded, and we've seen directors receive the benefits of a D&O policy whilst defending those types of claims. So the answer is yes, the policy could be triggered subject to its terms and conditions. The second part of Warwick's question is a very interesting one. If they didn't have the requisite licenses, would that cause an issue under the policy? I don't know the answer to that, but just off the top of my head, that might form part of the complaints, the claim and the allegations itself against the directors, that they were not operating lawfully, that they did not have in place the requisite licenses, and that in itself might have been alleged negligence on their part. So it might form part of the actual claim that has been brought against the directors. And absence, I would think, an express condition in the policy that says otherwise, it might be the case that the policy would still respond. You always have to go to the substance of the claim, and that's what our courts do. I might plead or particularize a claim in a certain way, but the courts reserve the right to go to the actual substance of the claim and actually say, despite how it's being described on paper, what actually is the complaint? And often when you're looking at policy coverage and whether a policy responds or not, you have to follow that same line of inquiry and go, what is the actual complaint against the director, and will the policy respond? I don't know if that answers the question.
I think it does. Thanks, Lee. Talking about the courts, Paul Lemon has asked, what proportion of claims submitted end up in court versus settled by the insurer before going to court?
So I don't know. I don't know the answer to that, because in South Africa, there's no sort of there's no database, if I could call it that way, or public record where you can track how many claims are actually instituted and then how many are settled. There's no ways of knowing. What we do know as a trend is that we are seeing more summonses against directors. So we know for a fact that there is more litigation today than, say, several years ago, where directors are cited as defendants in court papers, whether it's summonses or whether it's applications seeking some sort of relief, and directors have been sort of brought in on that litigation. As to settlements, that's impossible to say. I mean, any litigation attorney is taught to try and resolve matters. Litigation attorneys should be looking to resolve matters if they can, not to have matters heard in court. But that's a general principle, and each matter will be influenced by its particular facts. So it's hard to say.
Okay, got you. I think maybe we'll try to close off with this one because it's a bit of a composite of a number of things that you've been speaking about. If you can just pick up on what Anonymous has asked. They've asked, what happens if the claim circumstances arose from gross negligence or willful actions of D&O? Will he or she be required to refund the legal costs advanced by insurers? And could they be held personally liable for any indemnity payments due? Where the D&O acted out of the scope of duty, can the company be held liable? And if so, under what policy would they, as in the company, be held liable?
So I think there's a few aspects to that question. I think the first one is in terms of allegations of willful misconduct. Yes, there is the ability or the benefit under the policy to receive advanced defense cost cover, but yes, that is always subject to the right to the insurer to proceed to recover those costs in the event that the director is found liable for that intentional or willful misconduct, or where they have formally admitted to same. So there's a right of recovery ultimately under D&O policies locally down the line, depending on how sort of the situation plays out. In respect of the second question, again, I suppose just in the context of D&O, it's designed to protect the directors, not generally the company itself. So if the company has suffered a loss, remember it's the company that can proceed against the directors. So they would look to recover from the directors themselves.
Thank you so much, Lee. And for anyone who has to jump off of the call, we will be actually sharing the recording on our YouTube page. Our YouTube page is I2 Special Risks. And so you can have a look at the session again once we've uploaded it, and we'll let you know when we do so. But other than that, thank you so much, Lee, for joining us. I appreciate all the time that you've shared with us. And thank you to Vilja and Nadia as well for your excellent contribution. We appreciate you giving us these sessions in terms of the claim structures, because they are very much necessary in terms of brokers being able to know what they're dealing with when it comes to this product. So thank you everyone for joining us. We hope to see you next week, and enjoy the rest of the week.